What happens when you're not quite dead, but you can't make decisions for yourself?
Your will doesn't actually affect you. It affects the people you leave behind. The decision that someone else makes on your behalf actually affect you. You have to make sure that you appoint the right people. Appointing the right people is really important. People just think that clients come to me and say like, oh, I have to appoint this person. My job is to stress test that and say, is this the right person? Fulfilling your duty as an attorney, it would be smart if you were liquidating a major asset of someone's, particularly if the liquidation is to fund the lifestyle. I think you would be remiss in not fulfilling your duty if you didn't understand how that would affect, particularly if there was a will. So I would probably be asking, is there a will? And is this asset gifted to someone? And who is it gifted to? And who will it affect? Is this likely to cause an issue?
Hi, everyone. Welcome to another episode of the Investing for Doctors podcast. Today, we have Mr. Tyrone Dutt back with us today. As you remember, Tyrone is a solicitor and he specializes in wills and estates. Welcome back.
Thanks for having me.
Previously, we talked a lot about wills and, touched bits and pieces on estate planning. But I think there's one part of it which we haven't really mentioned, and it's not in that title, which is what happens when you're not quite dead, but you can't make decisions for yourself. And, we as doctors come across that pretty commonly, especially in the elderly, in terms of, power of attorney, guardian, and all of that sort of stuff. So I'm keen to hear from your side as a legal practitioner. What are the different bits and pieces, and how is that sort of stratified in the eyes of the law?
Yeah, sure. We previously discussed about estate planning and it being an umbrella term. And so we said your will is just one portion of your estate plan. It's just one piece of the puzzle.
When you die.
When you die.
Yeah.
Right. And then another piece of the puzzle is incapacity. And the two documents in New South Wales particularly that govern that is a power of attorney, which deals with financial decisions, and an enduring guardianship, which deals with lifestyle and medical decisions. So these two documents allow you to appoint someone to make decisions on your behalf when you have lost what we call testamentary capacity. So you do not have the capacity to make these decisions for yourself.
Before we go further, capacity, what exactly is the sort of the legal definition of capacity? Because we have a view on what medical capacity is, but like what does that mean?
Yeah, so I think it is really a subjective term because you as medical professionals probably perform a capacity test on patients before they provide you with instructions in respect of their health.
That's pretty much everyone we meet, really.
Yeah, that's right.
Is this person mentis compos?
Yeah. And I learned this from a doctor as well, that sometimes the capacity test can be happening and you not actually know that the capacity test is happening. So they're asking you questions like, how'd you get here today? What did you do today? Did you see the news today? Can you tell me what the date is? Things like that. Just conversational stuff that you don't actually realize that a capacity test is being performed on you. As a succession planning solicitor, I also have to do that as well. I have to make sure that my clients have what we call testamentary capacity, have the capacity to provide instructions on these documents. And so it is a subjective term, but performing a test to ensure that the client is aware. They understand what is going on and they understand the ramifications for their decisions.
And I guess when you're doing it on a normal person, it's a bit normal conversation and you have no red flags that this person can understand what you're saying.
Yeah.
So you don't have to officially perform a check for that to occur, right? But when things get a bit dubious for someone who's a bit elderly, they're forgetting dates or forgetting numbers, that's when you really have to make sure they have that capacity when you're getting the legal documents, isn't it?
Yeah, that's correct. And so I would probably have to be convinced that there's a difference between being forgetful and not having capacity. And so if there was that kind of red flag or essentially me being unsure of that, I would probably ask, particularly if they're elderly, to go and see a geriatrician and for that geriatrician to perform a capacity test on them. If they were younger then and they had a medical condition, I would ask for the treating doctor to provide opinion in respect of whether they have capacity to provide those instructions. So in that circumstance, and I think we've kind of jumped to the end here, because in that circumstance, I may not be able to act for that client because they've actually lost capacity already.
Yeah, and so
they can't give me instructions to provide that will.
Power of attorney. They can't create a guardian.
Yeah, that's right. Yeah.
Well, maybe we'll get into what happens then later on. But let's move back to the start. Okay, so when someone comes to you and asks for the sort of documents, and like a normal young person who is fit and healthy, do they come to you and ask for these things, or do you find that it's generally the sort of the older retirees that are coming to think about these things? Yeah,
sure. I don't think anyone comes and particularly asks for these documents. Or some do, but it's more my job to educate and say, this is how we can protect this scenario. And so a power of attorney, if we can start with a power of attorney essentially allows you to protect a scenario where, again, you've lost capacity, you're unable to make a decision for yourself, and you're able to appoint someone to make that decision, because like we just pointed out through jumping to the end, by the time you've lost capacity, you can't really trust that person's ability to appoint someone because they may not actually understand what they're appointing them for. So we make these documents when you have capacity. So we say, in the event that this happens, I want this person to make a decision for me. We can tailor that document pretty much down to how the client would like it. So for instance, a client may say, I want this person to make my financial decisions for me when I've lost capacity, and they have full reign. But a client may also say, I want to appoint this person, but I may want to make sure that they can never sell any property, right? I'm going to appoint this person, but they can never deal with my crypto portfolio, right?
It sounds like you've had that situation before.
I want to appoint these two people jointly, and I want to make sure that there's a checks and balance, because it's not just one person controlling things.
What about temporary versus permanent incapacity?
Yeah, sure. So you pointed out a really good point there, in a sense that, or issue there, that you can lose capacity, but then you also can regain it. And so with a power of attorney, particularly in New South Wales, there's a commencement clause. And the commencement clause, you can tailor that. So you can say, I want this power of attorney to start now. So this person can act on my behalf now.
Even if I'm completely normal.
Even if I'm completely normal. I haven't lost capacity, but they can start right now.
Okay.
Right? You can then, which is the general position, is to say that when I've lost capacity, right? But then you can tailor it and say, once a medical professional has provided a written opinion to say that I've lost capacity and unable to make financial decisions for myself, right? You can then tailor it to say an independent medical professional. You can say two independent medical professionals, right? So there is a commencement clause there in respect of when it starts.
And you have a finishing clause. If I regain capacity, I can rescind this, or I can just keep it going depending.
Yeah, that's right. And so it's important to also note here with powers of attorney, there are different types of powers of attorney. So something called a general power of attorney. And general power of attorney is, like I was saying with the first scenario, I'm going to appoint B to sign this contract on my behalf because I can't get there. So he's got the ability to bind me in that contract, right? But it is only active between this date and this date.
Or for a particular matter.
So
I guess when we nominate someone to vote on our behalf in the strata meetings, that's a power of attorney.
That's a type. It's what we call a proxy in a strata. But a power of attorney really just deals with financial decisions. I imagine you could use a power of attorney to enter into a proxy for someone, but a proxy is very different to a power of attorney in that sense. Okay.
Bad analogy, but
Oh no, the right analogy is just different type of area of law.
Sure.
So that's a general power of attorney. It's got a start date and an end date. It's got a circumstance in respect of when it is active. A general power of attorney also cannot operate once someone loses capacity. So I give you a general power of attorney and I say, okay, I want you to do this for me, and I've given you the authority to do so. But if it's found that I have amnesia or dementia, or I go into a coma, that general power of attorney is no longer active. In estate planning, we use something called an enduring power of attorney because it endures past the incapacity. Sorry. So, and that's the types of powers of attorney that when I talk to you about a power of attorney, that's the type of power of attorney I'm talking to you about. I'm talking about a power of attorney that will enable someone to make a decision for you when you've lost capacity. You can similarly put commencement conditions on it. So you can say, I want to start now, I want to start on this date, etc. In order for an enduring power of attorney to stop being active, you need to revoke it. So for whatever reason, if I've appointed you as my enduring power of attorney, but in 2 years' time I decide, well, B is probably not the right decision for me, I need to issue what's called a revocation. And it's a document that says, I revoke this power of attorney to B.
Yeah. And if there was conflict between these two people, they could say, no, you don't have capacity to revoke it, I guess.
Capacity in order to revoke is probably something that needs to be tested as well. And yeah, that can be a dispute as well. But generally, enduring powers of attorney, if you think about it, unless it's a control mechanism over like a parent or something like that, it's generally a onerous position to have because you're now controlling someone else's finances. Like everyone probably has enough issues controlling their own finances and controlling their own assets and things like that. To then take on that burden for doing it for someone else is probably a little bit onerous. But I would probably be remiss to say that people don't use it for sinister objectives because if I did say that, then there would probably be far less cases in court.
Yeah. I mean, look, we've got some Hollywood examples there with certain singers, but
so just to sum up, there, enduring power of attorney just allows someone to make a financial decision for you when you are unable to, and it allows you to appoint that person or people. It allows you also to appoint what we call substitutes as well. So I appoint you B, but if you're unable to do it, then I appoint.
And that can go the chain can go as long as you want.
Yeah.
Okay. All right. So now guardianship.
Yeah, sure. So an enduring guardianship, and sometimes in other states it's called medical power of attorney. It essentially does exactly the same as a power of attorney, except it deals with lifestyle and medical decisions.
So lifestyle and medical
decisions, okay. Right? So it allows, again, you appoint someone that when you've lost capacity to make decisions in respect of what medical and dental treatment you receive or don't receive, what kind of personal services you receive or don't receive, where you live or don't live, who can come visit you, whether you go into respite, whether you go into a nursing home, etc. And again, you can tailor these documents down to a fine T. So you can put instructions in there and say, I'm appointing this person to be my enduring guardian, but I never want to live outside of New South Wales. I never want to go into a nursing home. Okay. If I do go into a nursing home, I want to go here, etc. So they are quite important documents. I always start, everyone when they come to see me, they want to talk about their will. Once I finish talking about the will, I say, we can finalize that stuff in a minute. Let's talk about your capacity documents. The reason why I say it is because your will doesn't actually affect you. It affects the people you leave behind. Yeah. Your capacity documents actually affect you. The decision that someone else makes on your behalf may affect you because A, you're still living, but B, you may regain capacity. So in circumstances where, you go into a coma and you come out of that coma, if decisions are made for you whilst you have lost capacity, you have to deal with those decisions when they come back, when you come out and you have capacity again. So you have to make sure that you appoint the right people.
That's a very interesting thing. Yeah, you don't have to live with the consequences.
Yeah, because a lot of people think as well that, and look, it's a natural it's a natural thought as well, because a lot of people think that I've lost capacity, the next step is death. And you and your listeners would probably know that that's not the case on a daily basis.
No, yeah.
On a daily basis, that's not the case. But a lot of people think, by the time I've lost capacity, or by the time I get amnesia or whatever else it may be, right? Dementia, I go into a coma, or I have cancer that affects my ability to think. By the time I have that, the next step is death. But that could be years. So that's the first thing. So you may have lost capacity but still alive, and there may be years of that. But also, people survive cancer every single day. people come out of comas every single day.
Yeah.
And so they're just two examples. I don't want to focus on just purely those scenarios, but they're just two examples that I use where you may have to face these decisions.
And I guess similarly with the enduring power of attorney, an enduring guardian could be quite prescriptive as well. And, maybe divide one on lifestyle and say one on medical, because one child lives with me, but the other child's a doctor.
Correct. You can do that.
Yeah.
And again, you can appoint two to have a checks and balance against each other. Appointing the right people is really important, right? And people just think that clients come to me and say like, oh, I have to appoint this person. But you also have to think, and my job is to stress test that and say, is this the right person? So for instance, we had a client come to us end of last year, and she said, I want to appoint my sister as my enduring guardian and my power of attorney. She didn't have a spouse. So I said, okay, that's no problems whatsoever. So started like drafting, are you close with this? She said, yep, talk to her every day. Do you think she understands your wishes? Yep, no problems whatsoever. I said, okay, where does she live? Oh, she lives in South Africa. I said, okay. I said, what's the practicality of her being able to come here to make decisions for yourself? Right? What's the practicality? And I'm not saying that you can't appoint someone that's overseas, but if there was a real serious issue with you, chances are you would probably need someone on the ground, right? What's the likelihood of her being able to come here? And so appointing the right people or the right person is just as important as drafting the document. We have a lot of married couples that come in and appoint each other, and that's fine. Right. But when I say, what about a substitute? Sometimes they say, oh, we'll just appoint our children. I'll say, well, your son's 15 years old. So, we need to appoint someone that has,
is an adult.
Is an adult and has capacity.
Yeah.
Right. And so chances are sometimes that the married couple then appoint two different types of people. Yeah. So two different people. So the husband says, oh, I want my brother to act. And the wife will say, well, I want my sister to act. Right. And so stress testing that and saying, okay, if you are both incapacitated at the same time, right? What's the likelihood of both of your appointees acting in your best interest together? Because you have joint accounts, we have houses, we have properties, right? And so it's not just about simply just filling out paperwork. It's about, let's see how this unfolds, right?
Yeah, it's about thinking about the worst case scenarios and then trying to mitigate those worst case scenarios.
And
I'm
I'm paid to be a cynic. I'm paid to prepare for the worst case scenario.
Unknowns. You're supposed to bring up the unknown unknowns. It's like, oh, what if my sister and your brother do not get along and they have to make joint decisions for us and our kids?
Yeah,
And
so that's right, because the financial decisions will obviously affect the kids as well. If there are children. But I want to make sure that everyone understands that enduring guardian is very different to appointing a guardian for minor children. So when you pass away and you want someone to look after your kids, that is very different to an enduring guardian. It can be the same person, but it's got nothing to do with it.
I guess a guardian in a minor issue, the kids is more of like a foster parent, a surrogate. Parents,
well, it's essentially you're appointing someone to look after your children if you're no longer here.
Yeah,
right. And so that would be an issue.
The parental responsibility.
Yeah, that's right. Right. And we can have a whole podcast just on the issues with that as well.
Yes.
About the right appointing the right people and all the issues that come with that as well.
Yeah, because there's financial and also
that's right. And so, but is that person in Australia? What's the likelihood of them being able to look after your children, right? And so, like I said, we can have a whole podcast on that. But to go back to the capacity documents, I really think that they are the most important part of your estate plan, because the decision that you make and the person that you appoint, it directly affects you. Whereas your will and your binding death benefit nomination and things like that, it deals with people that you leave.
Affects others.
It affects the people that you leave behind, right? And that does deserve proper attention to it as well. You should provide proper thought and attention to that as well. But your capacity documents, it deals with numero uno, it deals with you. And so you have the ability, you have the control to say, if something was to go wrong, I don't want there to be any ambiguity. I don't want people to think, what do we do now? I'm going to appoint this person. And then the next thing after that should be information to that person. Okay. So saying, I've appointed you, right? You need to accept the appointment. They need to sign the document as well to say, okay, yes, I'll act on your behalf. And this is what I would like you to do, right? I want to make sure that this happens. I want to make sure that that happens. And if you don't have the proper trust in that person, you can limit their power. So like I was saying, can't sell any property, can't sell any shares, can't make any transactions larger than $10,000, whatever else it may be. But have that conversation with that person. Don't spring it upon them, because you may be in a situation where you appoint someone as a power of attorney or enduring guardian and they just don't actually want to accept that appointment.
Yeah, so when you actually do this, I guess the recipient do they have to countersign in the document?
Yeah, that's right. So for instance, if I was appointing you, I would say, I appoint B, these are the conditions in respect of my appointment to him. This is the commencement clause. I sign it. I get it witnessed by a solicitor, and then you would also have to sign it in order to accept it. In order for you to use that power of attorney, you would need to accept it. You would need to sign the document in order to accept it.
But just because I sign it doesn't mean I sign it willingly or under familial duress or some sort of thing.
Oh, look, I think that's
the sense of responsibility.
I think that's the case whenever someone signs the document. But yes, I think they need to understand what
the responsibilities,
the responsibility of the document and the appointment is, and if you have to convince them to sign it. So you say, "Oh, please, I don't have anyone else. Please sign it," etc. You need to have the confidence that when you actually need them to act on your behalf, that they're not going to abdicate from their appointment.
And can you pay someone to do that?
Can you pay someone to be your attorney? I think technically yes, you can pay someone to do it, but the question probably would be like why you would need to do that. If you didn't have anyone else, that's fine. But there are services like New South Wales Trustee and Guardian that provide that kind of service. They do take a fee in order to manage it for you, but I think generally speaking, it is probably an unpaid role.
Yeah, so if you went to the public trustees, then there's a fee with that. So
they would take a percentage.
Yeah. So it is technically a paid role because
and there are corporate services that do that as well.
Yeah. Okay. So they're corporate services that, but then in those situations, I guess you just got to be a lot more prescriptive in what you want. You just can't just leave it to them.
Well, that's right.
Ambiguous. Yeah.
That's right. And so it goes back to you have the ability here to make sure that you appoint someone that you trust and will do the right thing on your behalf.
Yeah. Beautiful. There's also this thing about advanced care directives, advanced healthcare directives, which we as clinicians see a lot in hospitals, and they always seem to come on random documents. And I always question, how legal is that? And can an enduring guardian overturn that piece of advanced care directive?
So an advanced care directive is essentially just a plan put in place for a certain circumstance. So it allows you to provide instructions that say, if this was to occur, this is what I would like to happen. Okay. So
let's use the most simple scenario.
Yep.
My heart stops. I don't want CPR.
Yep. So that would be a do not resuscitate.
Yeah.
And so if there was a do not resuscitate order there, then I think that it would probably have to be the healthcare practitioner, but the healthcare practitioner would know that that's the wishes of the patient, and so they would be bound by. Yeah.
So if I had an advanced care directive that is written and signed by the patient, and then you have the enduring guardian that comes along. I mean, obviously the guardian is aware of that document, but then the guardian says, no, I do not want to abide by the advanced care directive.
Yeah, so it's important to note that these, like whoever you have appointed, whether it be a guardian or an attorney, they're acting in your best interest, so the principal's best interest, right? And so they aren't to use those documents for their own agenda, right? So if we were talking about a do not resuscitate order, and look, this again becomes quite technical and quite convoluted in the sense that we're talking about emotion as opposed to law. And so there is a document that says, I do not wish to be resuscitated, right? For whatever reason it may be. The guardian can't use their appointment as enduring guardian to compel you as a practitioner for their own interests, right? But if the enduring guardian says, I had a chat with mum knows that there's a do not resuscitate order, but we need to go and get that changed. And then mum went into cardiac arrest. The enduring guardian is then acting on, the interests of the patient, because the enduring guardian then knows that the patient wants to revoke the DNR.
And that's a reasonable scenario.
If the enduring guardian is compelling you not to follow the DNR, purely because she doesn't want to lose her mum, that's a different story.
And in that situation, do I follow the DNR?
Well, different hospitals would have different policies in respect to that.
I know this is a hard question because it falls outside of your domain, but it's like legally, there is nothing wrong with following advanced care directive that contradicts the enduring guardian in terms of that you have a document, unless there was doubt to believe that the document was not done.
That's right. And which is what I was going to say. I said, I think you would probably have to deal with it on a case-by-case basis in respect of what information was presented to you. If the information was, there is a do not resuscitate wish, whether it be given directly to the hospital or through a advanced care directive, and there was information provided to a health practitioner or a hospital to say that that was an invalid instruction, or that instruction had changed, it would really just be a judgment call for that health practitioner at that stage. So if it's simply the enduring guardian saying, I don't want to lose the patient, so please resuscitate them, as opposed to there being a very valid order there. But if the enduring guardian said that DNR is actually quite outdated, it's 15 years old, we've had discussions since then, and I know that for certain she actually does want to be resuscitated, or they actually want to be resuscitated, that would really just be a judgment call for that practitioner. I'm going to go out on a lim here without. I'm
not going to hold you.
Well, I was going to say,
hold you to this. It's just like, what is your opinion?
I personally haven't seen a case where a patient has sued the hospital for being resuscitated. But in saying that, I could be wrong, right? Because it's not the area of law that I'm in. So it would really be dependent on, there would be a policy in the hospital in respect of if there was a dispute, what it would be like. And the policy for the hospital may say, well, if there is any ambiguity, we resuscitate, right? If there is no clear direction, then we're going to resuscitate, right? And then that issue be sorted thereafter.
Yeah, but on the flip side, we also have a lot of situations where you have very fragile patients and they have an outdated advanced care directive that say, oh yeah, I would still like to be resuscitated, have CPR performed on me. I'm okay for tubes. I think in those situations, then sometimes the enduring guardians will come and say, hey, this was written on this one, so you need to do this. I think on the flip side, there's also that ambiguity on a lot of
that's right. I think if a patient's given you clear instructions, again, we are going into
medical legal. We are going
into medical negligence here. But I would think if a client looks you in the eyes and you think that they have capacity, it's your professional opinion that they have capacity, and they've given you instructions in respect of their healthcare.
Oh yeah, I have to abide by that. Yeah,
right. Yeah. So I don't because in that circumstance, the enduring guardian shouldn't have any power at all.
Yeah,
right. Okay. They shouldn't be calling shots at all.
So even if they were sort of appointed as the enduring guardian, but then I see a patient and they seem mentis compass, I should go by what the patient says, obviously.
Well, because there's no capacity issue.
Yeah.
Right? So the enduring guardianship you should really, as a medical practitioner, I would think that you would only be looking for guidance from an enduring guardian when you cannot get those instructions from the client, from the patient.
Yeah, exactly. So they can override the guardian.
So if the patient has capacity and has said to you, yes, tubes, if I'm going to have this operation and, if my heart stops, I want you to resuscitate me, even though the DNR says otherwise.
That's
if
quite
they've
clear cut.
provided you with updated instructions, I would think that you would be
can't
well
rely
within
on
your,
document.
you would be well within your rights to comply by them.
Yeah. So it's a very interesting space because there's actually a ton of ambiguity in when there's conflict, and I guess in the law as well. When there's conflict, what do you do?
That's right. And so, but look, there would probably be plenty of scenarios as well where I would think that, say there's a DNR order put in place, and there's someone, and it sits with the GP or it sits with the hospital, and the person that's being treated has just popped down to the shops and has fallen into cardiac arrest.
Oh,
and
you don't have
from
that information.
That's right. You don't have the information. So that's why I think that if there was any ambiguity and you were going to side on the of caution, I would think resuscitate would be that side. I could be wrong.
No. That's pretty much what it is. Yeah.
But going back to the function of an enduring guardianship, the enduring guardianship is there to appoint someone to make a decision for you when you are unable to make a decision, and that decision is required to be made. So the doctor says, we need to operate, or we need to treat, or we need to do this, or we need to do that, or they need to go into palliative care or whatever else it may be, and the patient is unable to make that decision for themselves. That is when the enduring guardian would be able to say, okay, I can make this decision now because I'm empowered to make the decision. It also avoids the conflict. So if there was...
I think if there's always a conflict between the patient themselves and the enduring guardian.
Well, not so much about the patient and the enduring guardian, because if there's a conflict there and the patient has has capacity, I'm assuming that you were always going to follow the patient's instructions.
Right? Absolutely.
But I was thinking more in a sense that if the patient has lost capacity and you have multiple family members coming to you and asking you, what's the diagnosis, what should we do, etc. What's the next steps? If you have competing views in respect of what should be the treatment or not the treatment on that patient, it sometimes can be confusing for the practitioner. But I think as a principle, appointing a guardian, you would want to appoint someone that is going to be strong and to make the right decision, knowing that there's going to be that conflict, knowing that there's going to be that cloud. So you're saying, okay, I'm going to appoint this person or these people to make the right decision for me. They know my intention. And so I helped a really lovely elderly lady last week. She is 80 plus, but just full of life, right? Loves life. And said to me, because we were doing an enduring guardian for her, and she was appointing a son, and she said, he knows that I never, ever want to be a vegetable. I just never, ever want to be bedbound. And so if that was the case, she said, he knows that he has to be compassionate in those circumstances and just let me go. And she knew that her husband's passed away, but she's only got one son, but she knew that her brother and sister, which are still alive, would not want that to happen. She knew that if she appointed either of those, that they would not follow her wishes and that they would try and keep her alive. And so she appointed a son and she said, you know what to do, right? I've given you instructions of what to do. You know what my wishes are. And that's just a really good example of someone that doesn't want to die, but just wants a certain scenario to play out a certain way, right? And so if she's ever put in a certain condition where she isn't able to live life the way she wants to live it, that she receives or doesn't receive the treatment because that's her wish, but she just isn't able to communicate that wish at that time. So she's appointed the right person that will stand up and communicate that. I think estate planning, and particularly planning for incapacity, is a very emotional subject because you have to do the legal compliance thing with appointing the right people and making sure the document's right. But then you also have to make sure that you've appointed the right person to comply with your wishes. And that's where the healthcare directive comes in and things like that, because you're able to voice the shape of what you want to happen, and hopefully your enduring guardian's instructions also complies with that. But the enduring guardianship, like I said, it can be tailored in the sense that, these are the limitations. right? These are the extra powers I'm giving. I want to make sure that, in her enduring guardianship, she said that if I've ever been put in a vegetative state, I want to make sure that I'm made comfortable, I'm given pain medication, even though that may shorten my life. And I know that is a conflict with a lot of medical practitioners, and when it comes to when there are no enduring guardianships appointed, because there's a family member saying, we want her to be comfortable, she's in pain, and the medical practitioner may say, every dose of morphine we give her is slowly killing her. And so there may be a conflict in respect to that, right? In respect of what your duty to the patient is and what the family want. Yeah. And so having that enduring guardianship just allows there to be no ambiguity.
And that's interesting you raised that particular terminology, because I think historically that was, some people are morally objected to that. But in this day, sort of this generation, we're more sort of liberal with, sort of symptom relief. And that's all the whole palliative care sort of movements come around for that. Yeah. So it's actually very interesting that those specific words were used. Yeah.
Yeah, that's right. And it goes down to what I was saying at the start, where estate planning should be tailored, right? And so that clause may not be the right clause for the next client that I saw, because that may not be their wish, right?
But they need to know that that's an option.
That's right.
Yeah.
Right. And so we had a client that appointed an enduring guardian that would not have ordinarily known their medical history, right? So wouldn't have known who their treating doctors were, wouldn't have known who their GP was, etc. Right? And so we put a clause in that enduring guardian to make sure that it was very clear that any treating doctors, any GPs and things like that would provide all that information to the enduring guardian. So there was a right of information clause added to that enduring guardian.
Yeah. And I think even...
So you can make an informed decision. So
you clearly, yeah. And I think the thing is that if you are an enduring guardian, you can get that information anyway. But the thing is that it may not be offered up front once it's...
That's right. It might not be so forthcoming. So there may be a process in place.
You have to go and request it rather than being offered.
Well, not so much about the request as well, but also there may be some hesitancy from a medical practitioner saying, okay, who am I actually giving this to? How are you related to the person? I can see you've got this enduring guardianship in place, right? So, but they may not technically be a family member. And so there may be some compliance issues from like the hospital, the treating doctor, or whatever else maybe say like, am I actually being compliant by giving you this information, right?
We are educating doctors a lot better now.
So by having that clause in there, it just alleviates the ambiguity.
Yes.
It says, the patient has considered this.
Now I'm going to come with a slight curveball.
Yes.
Right. As we said, the enduring power of attorney and the enduring guardian can obviously be different people. What happens if it is different people and the lifestyle wishes and the financial wishes are in contradiction with one another? Yeah,
sure. So simply put, there will be a conflict. There will be an issue. So if the enduring guardian says, well, we need to put them into a nursing home or palliative care, etc., it's going to cost X. They need to communicate that to the attorney, and the attorney needs to approve the transaction of the money or the payment of the money. The issue that may occur there is maybe the principal doesn't actually have or cannot afford to go into that nursing home. Or they need to liquidate some assets. They need to liquidate assets, right?
Yeah.
The issue that flows from that is in the will, that asset may be gifted to someone.
Exactly. And then so once it's been liquidated for this purpose, then or they could say, oh, I do not want to sell the family home because I want to pass it on to my daughter, or for something like that. But to be able to afford the nursing home, then you need to liquidate that. Again, conflict resolution.
Conflict. So generally, if there's a conflict in that space, you're probably heading off to the guardianship tribunal, where tribunal members are tribunal members are lawyers or ex-judges. And on the panel, you'll probably find a medical professional, you'll probably find a social worker, some sort of financial planner as well. And usually the New South Wales trustee and guardian will sit on that panel as well. Yeah. So there is a bit of a holistic view in respect of and a practical view of how to solve that issue.
Okay, that's interesting. And in general, do they view certain things more with greater importance than other things, such as health and considerations, or is it all can go either way?
So are you talking about the Guardianship Tribunal?
Yeah, in that situation where I said, okay, you're no longer safe to live at home, so you can't be in a family home. We're not selling the family home on one side, but we need to sell the family home so you can go into care. That's a clear conflict. And in those situations, and I know your answer might be specific to that situation, not general. In your experience, would they more sort of side towards the medical needs and the lifestyle needs of the present versus the financial gains, from the inheritance for the daughter?
Yeah, sure. I think, and you're probably not going to like this answer. It depends. you probably hear that a lot.
Like a true lawyer. Yes. It depends.
So,
yes.
What I would probably think in that scenario is you would measure it up to the context of the situation. So, where are they going as a nursing home, right? How much is it costing? Is that relative to the needs of the patient or the principal in that circumstance, right? And so if they need to buy into a nursing home and that buy-in is $2 million, right? Why are we choosing that nursing home as opposed to something that may have a cheaper buy-in?
I see. So what have a workaround before you,
Yeah, that's right. And so, but the enduring guardian may say, well, there's a clear direction here for them to go into that nursing home. And that's the reason why. There may then be a decision there for the enduring guardian to measure up against, because the enduring guardian there is to protect and follow the interest of the medical and lifestyle of that, of the appointee, right, the principal. And the attorney is there to protect the financial decisions, right? And so there may just have to be a compromise somewhere along the lines of, do we actually really need to put them into this nursing home, or is there an alternative? And same thing with the attorney. The attorney may say, okay, if we do pay this out, what is the result of that? Is there going to be an issue with the estate when they pass away? What's the life expectancy of this? Like, how long are they actually going to stay in this nursing home? Is it really for the comfort of that person? And so are they going into a nursing home? They're going to stay in that nursing home for the next 15 years, 20 years, right? So it would be a checks and balance in respect of what is for the actual benefit of the patient or the appointee or the principal. So
now I've just pitted the power of attorney against the guardian. Now I'm going to pit the capacity issues with the will. So if things needed to be carried out from a capacity perspective, and we sort of briefly mentioned it earlier, but it will impact the will, such as liquidating certain assets that's in the will. Is there as much of an issue, or is that a easier thing to go down if both power of attorney and guardian agrees to do something, but then that will impact the will?
I think again, it depends kind of issue in a sense that, is the decision how much of an impact is it going to be on the estate, and what is the benefit of making that decision? So you're taking a risk and you're potentially liquidating an asset, which may potentially create an assumption issue in the will. What is then the impact of that, and what's the actual gain of that, right? And so if it is just we're gonna liquidate this asset to pay for this treatment, and we're only extending the life by a week, have you really fulfilled your obligation as an attorney? Like, is that a smart financial decision in order to do that?
Okay, so there's a sense check in that. But then if the will hasn't been carried out and it's only the guardian and the power of attorney, who's to stop them? So we use the same example as we decided to move into the nursing home, so we're going to liquidate the house. Who's going to stop them from liquidating the house? Because the will hasn't kicked in yet.
Yeah, so physically who's going to stop them? No one. But the power of attorney does have a duty to understand how the estate is going to be split.
Right. So they have to. So when they do anything, they have to also consider the will, and so they have to be aware of the will.
Well,
as
I think fulfilling your duty as an attorney, it would be smart if you were liquidating a major asset of someone's, particularly if the liquidation is to fund the lifestyle. I think you would be remiss in not fulfilling your duty if you didn't understand how that would affect, particularly if there was a will. So I would probably be asking, is there a will? And is this asset gifted to someone? And who is it gifted to? And who will it affect? Is this likely to cause an issue?
I'm just thinking of so many disaster cases in my head right
There
now.
are so many. But then, but then also thinking, okay, well, there's a buy-in for this retirement village. What's the buyout, right? And what is actually the effect?
So there can be a bit of like a
Is there an ability,
creative.
Is
sort of
there an
management.
ability? Is there an ability to avoid selling the asset?
Yeah.
Is there an ability for family members instead to fund
Come
that buy-in?
assist and we keep them. Yeah.
Right? And those family members may be the major beneficiaries of the estate. So it's about finding an amicable and workable solution.
Yeah. I mean, that's the best case. Yeah. And so it definitely means that, the enduring power of attorney needs to have some clarity over the will, if there is a will.
Yes.
Yeah. Okay. Yeah, this is, I think of horror cases, and I'm sure as a lawyer, you think of all the horror cases because we are both risk mitigators.
Yeah.
Right? We see what's the worst thing that go wrong. We make sure they don't happen. Us from a health, you from a legal perspective.
Yeah, that's right. And so I think I said in a previous podcast, it's part art, part science, in the sense that you've got to manage emotion against risk.
Yeah.
And so what may be financially correct may not be morally or emotionally correct. So it's about having that balance. And that's where it comes back down to, and I sound like a broken record, but appointing the right people. Yeah. Because some people are just able to act in those scenarios.
Yeah.
They're able to manage the stress. They're able to manage and
the conflicts.
Yeah, and make decisions.
Yeah.
Because at the end of the day, that's what it is. You need to appoint someone to make a decision.
So get the right person.
That's right.
Yeah. Beautiful. So look, I think we touched quite a bit on that, and I think it will help us as medical professionals to even understand a bit more about these things. And so really thank you for your time today.
Yeah, no worries. Thank you so much for having me.
And I've got a few more topics for in the future.
Yes.
Yeah.
Love to be here. Thanks so much.
This podcast is for educational and entertainment purposes only. The information and opinions shared are not intended as personal financial advice. The content presented should not be relied upon for making financial, investment, or other decisions. Listeners are strongly encouraged to seek the advice of qualified financial or legal professionals before making any financial decisions. While we aim to provide valuable and accurate information, we make no guarantees regarding the completeness or accuracy of the content. Any reliance on the information provided is done at your own risk.